Good day, Madam Khadija and my fellow friends. We are from Group 4 Industrial Property class. Recently, we have just learned about the topic of trademarks in our class. In Malaysia, it is specifically governed under Trademarks Act 2019, here in after TMA. According to Section 3 of TMA, we can know that a trademark is a sign used to differentiate one enterprise to another. It plays a significant role in one enterprise because the public will view it as an indicator of connection between the specific goods or services to the trader or manufacturer. In this video, we'll present to you trademark infringements arising between OLR, OLOR, and Oller, OLOUR. Nasrin will be acting as the clients from the Oller, while Genevieve will be the senior counsel, Inani and Jun Ni will be the junior counsel, and I, Yap, will be the narrator throughout this video. Now, both client and counsels have entered into the Zoom meeting rooms. Let's take a look of what's happening.
Good morning, Miss Nasrin. Nice to meet you. I'm Genevieve, the lead counsel in this case, and you can call me Miss Ling. Together with me is my partner.
Okay, hi, I am Fatin Inani. Just call me Inani. Thank you, Miss Nasrin, for choosing Junani and Associates. We have been specialized in the field of trademarks since 2000.
Yeah, my pleasure to meet you, Miss Lim and Miss Inani.
Red, it's unfortunate that we could not meet out physically since COVID-19 is getting serious right now. We do hope that you are safe and stay healthy. Thus, we are having this virtual meeting to hear more details on what's going on and what made you reach us out. So we will then briefly explain how we support you.
Okay, so before we enter into our interview properly, there are a few things that I need to clarify, which is this is our retainer form, which you have to sign before taking any legal action. And second, regarding the content of our meeting today, everything we discuss will be private and confidential. Lawyers or clients are not allowed to expose our conversation today to any other third party.
Our meeting today will take about 30 minutes. Is it convenient for you to be with us for that long? We will make this meeting simple and fast. Please feel free to ask us if you have any questions.
Yes, no problem. I have decided my plans ahead, so we could focus on the session. The story actually went like this. I have a business in Kuala Lumpur for 10 years, and the products that I have sold include my top-notch exclusive perfume under the trademark of Olor. And I have to say it's broadly used and popular among the public. My Olor is also quite famous, and it's spreading among one another. So it started to bother me when there is a new company that has just opened in Kuala Lumpur about 3 months ago. So they call themselves Olor, OLOUR, which is different in spelling. So that's the reason why I decided to consult with you today.
Okay, so first and foremost, have you registered your trademark?
Yeah, well, I did register my trademark Olor for all of my goods in relation to cosmetics and also cleaning substance around 10 years ago. But I think it shouldn't be a problem because I am the registered proprietor in Malaysia. How can they make application to register a similar trademark and sell the goods that are similar to me?
I see. So do you know what products they sold?
If I'm not mistaken, I was told that they are selling soaps, face washers, and also towels.
Okay, so do you have anything that you want to add more to your information given?
I think if I would like to add is a few days ago, my team has made an investigation. They found out that they have been using the trademark Olor in Malaysia for about 3 months, I think. Yeah.
Okay, so let me summarize it for you. So the situation that you are facing now is that you have already opened your business under the mark of Olor, OLOR, for 10 years, and your business trademark has been broadly and well known regarded in connection with an exclusive perfume. But there is one business name, Olor, OLOUR, newly opened and have made an application to register the trademark, which they have been using it for 3 months in relation to selling soap, towels, and face washer, is it?
Yeah, exactly. So I would like to seek your advice on whether I could in any way prevent them from having almost the same trademark as mine, because I am so worried that it would affect my business in some way. So, is it possible for me to oppose their application?
Don't worry, since Olo is the mark that is used for distinguish your company and another is a trademark under Section 3 of Trademark Act, and we know that your trademark has been registered earlier than the Olo, such earlier trademark under Section 5 and can be beneficial to your case.
I see. Will there be a high chance for my opposition to succeed?
You can raise the legal action under the grounds that it's likely to cause confusion to the public. Well, the registrar themselves should refuse their application. At the first place, refer to Section 24 2b. We also have Section 9 to determine whether it will cause confusion. Basically, the court will compare the look and sound of the word marks. Take our precedent case, Jordans and Jordan, as an example. It was confusingly similar in their phonetic. Now, in your case, we are in the view of Olo and Oro, resemble in sound and look. Therefore, you can raise the ground to protect from any risk of deception or confusion.
I see. That's a relief. So this means that I can just use this ground to refuse the registration, right?
Absolutely. All this is stipulated in law, which is Section 34(2) of Trademark Act, and you may first consider paragraph A for similar class.
Wait, hold on. May I know what you mean by the classes? How do I know which classes that my products are listed?
The class here can be regarded as the type of goods or services provided under the trademark. In your case, the perfume, cleaning product, cosmetic are under class 3, and the company using the Olo trademark, which sells soap, is also under class 3, while towel and face washes is in class 24, tester.
Thank you. I understand now.
Alright, so let's continue. As for similar goods, you may oppose their registration under paragraph of Section 34(2) under the ground of likelihood to cause confusion. As for non-similar goods, you may oppose under paragraph C as your possesses a well-known trademark. To conclude, you may successfully oppose the third-party trademark application on the ground of its likelihood to cause confusion.
Well, that's good to hear.
To summarize the first issue, our client is deemed to be an earlier trademark under Section 5. Our client has a ground of opposition under Section 34, subsection 2. When referred to the Section 24, subsection 2, paragraph B, our client has a ground of refusal of registrations as there is a likelihood of confusion to the public, as determined under Section 9, which is to consider all relevant circumstances of the case. When it comes to the goods that are non-similar, our client has the ground of opposition under paragraph C, as our client is the well-known trademark in Malaysia. So what constitutes a confusingly similar trademark? The court in the penalties case has compared the conflicting word marks by considering both look and sound. In the following cases, the court held that their trademarks are confusingly similar to each other in terms of their phonetically similar or their wording closely resemble to each other. In our case, our client OLR is confusingly similar to the third party's trademark OLOUR, so our client can expect to successfully oppose the third party's trademark application in our situations.
So counsel, can I say that we are able to prevent third party from using the trademark OLOR in relation to soaps?
Well, for your case, we know that the soap is in class 3, same as your exclusive perfume. So we will first focus on your rights under Trademark Act and whether there is infringement and what action we should take.
Yeah, please do tell me more on this.
Okay, so as you say that you have registered your trademark, right? You will have exclusive rights under Section 48 of Trademark Act, which is to use the trademark and authorize others to use it. Besides, you can obtain relief when there is any infringement.
If that's so, could you explain more on how to ascertain if there is infringement of trademark in the similar cases?
Yeah, sure. If the similar trademark is used under the same class, this may constitute an infringement of trademark, which stated under Section 54, Subsection 2, Subsection B of Trademark Act. The reason for regarding this as trademark infringement is to prevent the trademark being used bearing the similarity which will later cause confusion to the public. As for mentioned before, the registrar will not register this trademark pursuant to Section 24, Subsection 2, and Subsection B.
I see. I understand now.
However, to determine the trademark infringement, there are some elements under Section 54, Subsection 1 that we need to fulfill. First and foremost, the opposed party shall have a similar trademark with yours that is likely to cause confusion. Second, they must not be the registered proprietor nor registered user of the trademark. Third, that offending mark must be used in the business. And last, they are used within the scope of your registration. And then they use it as trademark does, which include in packaging or in television advertisement. And fourth, the third party has used the sign for goods or services within the scope of the registration.
I see. That's a good explanation. Now I understand how infringement could occur. So, is it possible for me to not let them use the Ola trademark for their soap products, since perfumes and soaps are different?
Of course, yes, because perfume and soap are in the same class. As you have satisfied the element that I mentioned, you may initiate the court proceedings against Oler, OLOUR. You may also obtain relief like sought or for injunction to prevent their goods enter into commerce as provided in Section 56.
I see. It's very good to hear that. I'm so sorry for asking too much. It's just that I have to know what are the options that I can avoid best.
To summarize the second issue, first, Section 16 provided only registered proprietors of trademarks are entitled to right and remedies under TMA. Under Section 40 Act, Paragraph 1 gives the power to use trademark and authorize other person to use it, and they can obtain relief if infringement occurs under Paragraph 2. When using the similar trademark without consent is the act of amounting to infringement under Section 54, Subsection 2, Paragraph B, read together with the Section 24. The elements to establish include in the Section 54, Subsection 1 is the unregistered similar trademark must be used in the course of trade in relation to goods or services within the scope of registrations. Our client has satisfied these elements, and our client can initiate the court proceedings as stated in Section 56, Subsection 1. The court may grant relief like injunction to restrict the use of the trademark by third party pursuant to subsection 3. In these two cases, for the first case, the plaintiff and the defendant used the identical trademark, which is Giordano, in selling the goods in the similar class. In the second case, the plaintiff and the defendant have the trademark, namely Jordache and Jordan, to sell goods in the similar class. In both of the cases, the court grant injunction to them. In our case, soap and perfume are in the similar class. The third party have done the act of infringements by using the similar trademark in the similar class, as our client can prevent them using the trademark by sought an injunction from the court under Section 54.
So, how about Olar's face washers and towels? Can they not use the same trademark too? Because if possible, I would not like them to use the same trademark for that.
Well, as for this situation, it would be different. The face washers and towels are not under the same class as yours. It's under class 24. If it is so, they cannot be prevented from using the trademark OLO. There is no infringement between the trademarks as stated in section 54 2b due to different classes with the OLO. However, there are possibilities to cause confusion and deception to the public based on the section 24 2b since most of their customers are Malaysian.
So even if they could cause confusion to the public, I still cannot do anything?
It's hard to take legal actions as there is no infringement because the goods sold by the third party are in different class with the goods sold by you. There is one case called Bonia International Holding, and it was having the similar situations as yours.
So what's this case about?
So in this case, the plaintiff was selling fashion product under the mark Colorino while the defendant was selling eyewear under the mark color Renault. Due to this similarity in the trademark, the plaintiff sued the defendant for the trademark infringement. But because the trademark registered by both plaintiff and defendant were in different classes, the plaintiff failed to show how the defendant's trademark could deceive the public. Thus, this charge was ignored by the court. So, we would advise not to take legal action for the goods of face washers and towel.
Well, that's disappointing, but it's okay. I do expect this thing to happen anyway.
To summarize the third issue, as aforementioned, Section 54, Subsection 2, Para B, with Section 24, Subsection 2, Para B of TMA is provided for confusingly similar trademark among similar or identical goods or services. This means that the non-similar goods, even they have the similar trademark, will not fall within these categories. Let's look at the Consitex SA case. The plaintiff registered as Jagna in class 25, while the defendant registered as the Jagna JCNA in class 16. The court held that there's no confusion as their target market are different. Whereas in the Bonia case, the plaintiff with the name Carol Reno, brand under class 3, 14, 18, and 25, and service under class 25 is totally different from the defendant had registered the Carol Reno trademark in class 9. But however, there's a very rare cases where the YTQ case, the appellant bear the trademark of X1R, or the respondent bear the trademark of X1. The court held that as their end user was the same, so it will be confusingly similar to each other. In our case, we would like to conclude that our client cannot prevent the third party from using the mark order which in relation to face washers and towels as they are under different classes. So there's no infringement based on Section 54, Subsection 2, Para B. So unfortunately, our client cannot prevent the third party from using the trademark order under this act.
Since some of the options are not really applicable, may I know if there is any way I could improve my trademark status legally?
Yes, I was kind of hoping you would ask that because there's no need for you to worry. In your case, you can choose to raise the legal protection of your trademark under well-known trademarks.
What is that? I have no idea on this.
Well, well-known trademark is those popular trademark which has been recognized and has goodwill in Malaysia as per Section 4, Subsection 1 of Trademark Act. And for your information, Malaysia is a party to Paris Convention, so thus it is protected as well-known trademark under its Article 6, Subsection 2 as well.
By right, how do we know if one trademark is a well-known trademark?
Okay, by following the criteria set up in Regulation 5, firstly, it relies on to what extent public in relevant sector know or recognize the trademark. The subsequent criteria are the duration and geographical of that trademark was used, promoted, and where the application was filed. The registration of a trademark must also be recognized by competent authorities and have the value associated with the trademark. Considering your business or law has already established its brand and is quite well known since its trademark has been registered for 10 years, it's hard to imagine people who haven't heard or used your perfume yet. So you shall fall within the well-known trademark.
I see. So does it make me extra special? I'm sorry, but I don't see how the well-known trademark will help me in improving our position.
So we believe that you have no reason to worry, Ms. Nasrin, because our law, Section 34, Subsection 2, Subsection C, protects the well-known trademark owner from other similar trademark, no matter if there are different classes. Of course, prior to it, there must be a connection between those goods with yours, and then such use will cause likelihood of confusion and damage your interest. You may subsequently apply for a declaration to invalidate the offending registered trademark under Section 76, Subsection 3. So in your case, I believe
see.
they will face a consequences if they were to find out that they have infringed your trademark for the reason I have mentioned to you before.
I see. So that's very good to hear. What about the protection for this well-known trademark?
So as we all mentioned just now, this is our only suggestion, as our discussion today does not form any lawyer-client relationship, so we will not take any further action without your permission.
Okay, that's good. Surprisingly, I managed to understand all of that. And thank you for the advice given. I appreciate it.
Jen, you have anything to say?
You can take your time and consider properly what is the most ideal solution that you wish to have. You can contact us again anytime when you come out with a decision. We can arrange a second meeting later on.
Okay, thank you for the advice again. I will consider all of them properly.
Well, thank you. Hoping to listen from you soon. Stay safe.
Bye. Take care. Stay safe.
Take care.
A quick recap. Malaysia is a party to Paris Conventions. It refused trademark with the probability to create confusion or dissensions. TRIPS agreements further extend it to prohibit the unauthorized use of the well-known trademark. Well-known trademark is defined in Section 4 as a widely known trademark in Malaysia. Refer to Regulation 5. The criteria stipulated include to what extent it is widely known in public, the duration and geographical area of that trademark was used, promoted, the application was filed, and lastly, the recognition from authorities and associated with value. The legislature can refuse the similar trademark to well-known trademark, provided that it satisfies there's connection between goods or service and the proprietor of the well-known trademark, and such use of the trademark cause a likelihood of confusion and damage the interest of the proprietor. Our client can raise the ground of oppositions under Section 34. The protection of the well-known trademark is stipulated in the Section 76 of the TMA. It means that the owner entitled to seek an injunctions, and it has further right to seek for declaration of invalidations of a registered trademark under subsection 3, provided that the condition listed was satisfied. In the Canon case, the plaintiff owned a Canon, C-A-N-O-N trademark, which was registered for various electrical goods with high reputation like printer, whereas the defendant, Canon's, C-A-N-N-O-N, is now filing the application for the video tape cassettes. The court refused such applications due to plaintiff is a well-known trademark. The same goes to the Carimore case. Applying here, our client as a well-known trademark can take action to oppose third party under Section 34 and file an injunction and declarations under Section 76. The night after the consultations, the client agrees to take legal action against the third-party trademark. There's one counsel responsible for carrying on the research on the background of our client trademark. She also checked through the MyIPO official portal on the trademark. Surprisingly, she notices that there's one trademark very similar to clients, named Oleur, O-L-E-U-R, which was registered in Malaysia about 11 years ago. However, this trademark has not been used for 5 to 7 years before it was bought by the current trademark owner. The counsel finds that earlier is a very important issue that will affect the client's trademark. She immediately informs the client and has a second discussion with her.
Okay, hi, Miss Nasrin. Nice to meet you again.
Inani, what's going on? I'm not clear about what you mentioned in the call. Someone is using a similar trademark as mine. I don't even know about that.
Miss Nasrin, our counsel, Miss Jun Ni, found out that about the issue and was responsible for this. She is here today, so she will explain to you the whole findings.
All right, Miss Uni, please tell me what's going on. My Olor has been standing proud for years now. How come there was a trademark similar to mine? What is that trademark?
Okay, Miss Nasrin. The said trademark is called Oleo. It was registered in Malaysia on 10 February 2000. And we assume that you might not realize the trademark because this trademark was registered for different classes of goods. Your Olo trademark is registered for cosmetic, perfume, cleanser, which is more related to skincare. But this Oleo trademark was registered for paint, varnishes, and more related to hardware.
Wait a minute. So I actually have seen this trademark before, but it was very long time ago, probably when I was still in secondary school. I wouldn't even remember if you had not shown me this. But is the business still carry on? Because I thought the company has gone bankrupt.
Yes, indeed. It was an old trademark belonging to Enterprise DEF, and the trademark has not been used for about 5 to 7 years. But recently, this older trademark has been brought by Enterprise GHI and has been used for 3 months. Now, the Enterprise GHI is applying to extend this trademark to include the goods such as substances for the polishing, scoring, and abrasive preparation.
So this means that it is not cosmetic or any cleanser. And this business is very different from what I'm selling. So will their business affect mine?
Miss Nasrin, even though the goods are different, but it also belongs to the goods under class 3, which is the same class as yours.
Same class? Oh my god. The color is listed under the same class as mine, and your colleague said this is trademark infringement. This will certainly affect my Olo trademark. What should I do, Miss Juni? I really need your help in this.
All right, now we have two options for you in this case. And the first option is called as revocation of trademark, which means that we have to take this case to the court and ask the court to remove the trademark due to the non-use.
I see. It will be good for my business if we could revoke their trademark. So, may I know what I should prepare to apply for this revocation, or is there any documentation that I have to prepare as proof?
In this revocation of trademark, Section 46, subsection 1, paragraph B provides that you have to show to the court that you are the aggrieved party, which means that you are encounter some difficulties or problems because of the existence of oleo trademark. So if you could find some evidence to show that the trademark have brought some detriment to your business during that 5 to 7 years, it will be helpful in this application.
Well, I would say that it's not going to be easy because this trademark has been used by other entities, and there is no doubt that it will be a hard process for me to search for the proof, especially when it involves information dated at the past 5 to 7 years ago.
I see. If it is so, we still have a second option for you. This option is known as injunction. It is used to stop the enterprise GHI from using the oleo trademark.
Honestly, at this point, I am willing to hear anything that you can offer me as solutions, just for the sake of my business.
Well, we will make this suggestion because we can see the oleo trademark and your oleo trademark are so similar, and both of them are registered under the same class. And this will create a likelihood of confusion to the customer. So under this option, we can apply the Section 34 of Trademark Act for injunction and read together with Section 24 likely to cause confusion to the public as our ground of opposition.
That's true. I don't doubt that. I really not want people to assume that their products are the same as mine. That is absurd. I have been working on producing a high quality fragrance with excellent notes for my perfume. So people must be thinking that their soaps will have the same quality as mine. So no.
We understand your feeling, Miss Nasrin. You're right. Over the trademark, it certainly cannot be overridden by any other third party.
I hope so. I cannot imagine if the things that I have been working on went just like that.
So by comparing these two options I made, I would suggest you to go for the second option, which is the injunction. As you can see, the injunction is meant as a restraining order granted by the court to protect against the other party from inventing or threatening our trademark. And we will have a clear provision and evidence to show that the oleo trademark is substantially similar to your oleo trademark from both size and sounds. So by comparing to the revocation, it sounds a bit hard because you find hard to get the evidence showing that you face some detriment due to the non-use of oleo trademark, isn't it?
Yes, it seems to me that this injunction process will be a bit easier compared to the revocation application.
Well, we'll later prepare the file and application for the injunction to protect your trademark against the infringement. If there is further information, there is a need for further clarification, we will contact you for more details.
To summarize the authorities of the issue B, we have provided two options for the clients. Firstly, revocations. It is stipulated in section 39 that the duration of a registered trademark lasts for 10 years. However, if not being used for more than 3 years, an aggrieved person can apply for revocations under section 46, so that the rights of the previous owner will be seized, provided that it is revoked for the no use in good faith for 3 years, or there are no proper reason for the suspension of use. There must be a proof of non-use for 3 continuous years. In Godrej Sara Lee case, the court allowed the revocations due to 3 years of non-use from 2004 to 2007. What is an aggrieved person? It is defined in Service Master case that an aggrieved person must possess a genuine interest in the trademark and have to suffer the substantially damage. We provide for the option 2. First thing first, there's an assignation in our case is provided under section 64 subsection 1, where a registered trademark can be assigned as a movable property. In Chok Fok San case, the Milan trademark was passed over to the next new owner through purchasing. In this circumstance, our client has the ground of oppositions under section 34 subsection 2 para A read together with section 24, in which our client can oppose the use of the similar trademark in same class. Furthermore, our client can sought an injunction under section 56. In our case, we will highly recommend to choose option 2, as option 1 might be failed if unable to prove our client is an aggrieved person.
That's very good to hear. I can see now why a lot of my friends have been suggesting that I consult with Junani and Associates. I have been given good options and I have been told which options that could benefit me the most compared to others, and I'm so glad. So thank you so much.
Welcome. It is our pleasure to be able to help with you. If there's any other question, please do not hesitate to contact us. We are more than happy to assist you.